Hello everyone, this is Rajiv S. Khanna for immigration.com, the losses of Rajiv S. Khanna PC. I wanted to record a video at the request of a community member who is a senior, a parent of a US citizen. They come and they visit, and a lot of people are in that situation. When parents come and visit, are they required to continue to stay here for a certain time? How does the naturalization process work? So I think it's a difficult topic because it has many components. Let me start from giving you an overview of the way uh, maintaining permanent residence in USA works. Uh, let's begin with this flow chart. What does the law require? If you have a green card, all right, so now you got your green card. What does the law require? The law requires you to have a permanent home in USA. Okay? Permanent home in USA. There is no artistic definition of what permanent home is. If you in fact live in USA, your permanent home is in USA. I'll get to the specific questions posted by this gentleman from our community in a minute, but I want to just talk about the law in general. So your permanent home must be in USA. There is no artistic definition. It's a simple question. Where do you live? If the answer is I live in USA, you're okay. Okay? That's the first step. What if I have to take a trip outside USA? Well, is it a one-time trip or or infrequent trips, or you're just going every year for a couple of months or a month? That's okay. That's not a problem. What if you are going every year for 5 months? That's frequent trips or a pattern of trips that you repeat every year. At some point, USCIS can raise a red flag on that, because the idea is, are you really living in USA or are you really living in your home country? Okay, so if there's a pattern, even though the pattern involves travel of less than 6 months in any 12-month period, but it's a pattern that has existed for a long time, a few years, they can raise an objection. They can ask you, where do you live? Okay. One thing I want to add, by the way, if a green card holder shows up at a US airport, the government has to let them in. Even if they are claiming abandonment, government has to let them in, and they can lift the green card and they can say, we are taking away your green card and you have to report to immigration court on this and this date, but it's not like they can turn you back at the airport. Going back to what we were talking about, frequent trips or a pattern of trips. What if my trip is less than 6 months? Usually there's no problem. Any year you want to go out for 5 months, 5.5 months, it's not a problem for your green card, it's not a problem for your naturalization, unless there's a pattern. If there's a pattern, then they can start creating issues. My next point on the flow chart is, what if the trip is less than a year but more than 6 months? That can require an explanation at the airport. There's actually a technical term called entry. So anybody who's been gone less than 6 months is not really, or not anybody, but a green card holder is not really seeking entry. They are not considered to be subject to a bunch of technical requirements that people would be if they were gone for 6 months or more. Or is it more than 6 months? 6 months or more, let's assume that. More than 1 year outside USA without re-entry permit. If you don't have a re-entry permit, Form I-131. I've got a video on I-131 and N-470. These are two forms that help you preserve your green card, and N-470 helps you preserve your stay outside USA for naturalization if you are engaged in missionary activity, working for the US government, or involved in advancing trade, international trade on behalf of a US company. So it doesn't apply to many people, especially to parents who are coming, or they're retired, they're just coming a few months in a year, for them it doesn't really apply. But re-entry permit protects you, not 100%, but to a certain extent, against allegations by the government that you have completely abandoned your permanent residence. So if you're outside USA for more than 1 year without re-entry permit, your green card is gone. Next point on my flowchart is what to do if you've been outside USA for more than 1 year, I should say, not 1 year, but more than 1 year without re-entry permit. Well, there are only two choices. You can apply for a returning resident visa through the consulate in your home country. It's also called SB1. S Sam B Boy 1. SB1 visa. There you have to pretty much explain in quite some detail what the genuine reason was for your inability to return to USA within 1 year. Then it's discretionary upon the consulate whether they are convinced with the genuineness of your response or not. So if you've been outside USA for more than 1 year, green card is gone. If you can get returning resident visa or SB1 visa, same thing, called the same thing, you can come back. Of course, your child, your son or daughter, can apply for your green card again. Okay, or if you have a green card through, unfortunately, if you have it through a brother or sister, that will take 13 years again. Okay, so that's the way you can get your green card back. One question I have been asked a lot, actually yesterday, no less than 3 people asked me the same question. Okay, what if I surrender my green card? Will I easily be able to get certain kinds of visa like B1, B2, tourist, business, F1, which is student, or J1, exchange visitor? And the answer is we don't know. On the one hand, the fact that you have given up your green card should be considered to be the ultimate proof that you don't want to live in USA. But government can sometimes ignore that and consider that to be actually a negative point that you had a green card and maybe you are trying to get back into USA. So sometimes you can have problem getting B, F or J type visas. Of course, for certain visas for which immigrant intent or intent to live in USA is not an issue, like H1, H4, L1, L2 visa, you would not have any problem getting those. Okay, so that's what I wanted to cover, at least in the way of the general law. Now I want to show you what USCIS says about this. I extracted this from the USCIS website. Oh, this doesn't work. So let's just go back to this. So USCIS says, if you do anything which makes you removable, for example, if you commit a crime, etc., which is not a problem for us. But then they talk about abandoning permanent residence. If you move to another country intending to live there permanently, right here, okay. One of the things that USCIS looks for, not just in case of parents, but in case of any immigrant who is outside USA, if you leave your job in USA and get another job outside USA, that's a very sure indication that you have abandoned your permanent residence in USA. Also, if your family is living in your home country, not USA, then USCIS can consider that to be also evidence that you've abandoned your permanent residence in USA. If you remain outside the USA for more than 1 year, we know all that. The last two points talk about if you fail to file an income tax return while living outside the US for any period, or you declare yourself a non-immigrant on your tax returns, you will lose your green card. But what if I'm not required to file tax returns? That's one of the questions this gentleman who sent me an email asked me. Am I required to file an income tax return? I don't know where that observation from USCIS comes from, because the way I see it is, if IRS doesn't require you to file a tax return, you shouldn't be filing one. There isn't a problem. Okay, so I looked at the IRS publication P as in Peter 4588, And this is what I've opened just now is IRS publication 4588, and this part that I've highlighted, you are not required. See, it tells you if you have a US green card, you are a lawful permanent resident. Even if you are a green card holder for 1 day in that year, you have to file income taxes, except when your gross income from worldwide sources is less than the amounts that require a tax return to be filed. So if your income is below a certain level, I don't see why you should be required to file a tax return. In my view, the information on USCIS website is a little misleading. It does not provide for those cases where a tax return is just not required to be filed. That's the way I see the law. Okay, but I'm no tax expert. I will readily admit that. In my view, it's not required. Now, going to the questions that our respected community member has, he says, and I'm going to start here. Can the GC holder travel to their native country for 160 to 170 days? As I said, as long as you are maintaining your permanent home in USA. The question is, what is permanent home for somebody who lives a few months here and a few months in their home country? Difficult for me to say. Maybe a separate bedroom for you in your children's house if you're living with a child. Maybe your bank accounts here, your license, driver's license, anything that a person who is living in USA permanently would do will strengthen your case. So if you have a pattern of going back to your home country for a few months every year, and it's 160 to 170 days, which is just short of 180, it appears to USCIS that maybe you are not really seriously maintaining your green card. That's what I would be worried about. However, if you have other indicia, other indications that you are actually living permanently in USA, and again, this is not a term of art. There isn't anything here that I can say is very scientific or artistic or esoteric that I can't explain to people. It's just common sense. Whatever a normal person, and by normal I mean you, for example, what would you do, sir, if you were living in USA? What kind of amenities would you create for yourself? Would you rent your own house, buy your own house? Whatever it is that you would normally do, if you follow that through, I think you have a fairly good chance of surviving any challenge by the government that you've abandoned your green card. Okay. And by the way, for naturalization also, if the green card has been abandoned at any time, any point of time, there can be no naturalization. Question number 2 is 99% people are dependents, totally dependents on their children. They don't have any income. Is it necessary to file income tax returns? In my view, no. If IRS does not require you to file tax returns, I don't see how USCIS can. In my view, you shouldn't have to file tax returns if under the rules of IRS you are not required to. May you file nil taxable income? I don't know how to do that. You have to ask your CPA. Will it affect for filing their naturalization process? I haven't done extensive research on this issue of tax returns, but from just what I saw in a couple of minutes of review, it did not appear to me that a tax return should be required. If you want to be even more sure, what you can do is contact your congressman's office here in USA and just tell them to find out the answer for you definitively. I am unaware of the source of this requirement. I don't see where USCIS gets off saying you've got to file taxes. What if the law doesn't require you to? Okay, so go to your congressman's office. They might be able to confirm. I don't want to spend a whole lot of time trying to dig out this issue, which is in my view a marginal issue. Third question, can they continue to hold green card for say 7 or 8 years? In 9th year, they may file for naturalization. The answer is yes, as long as you meet the requirements for naturalization and you have not abandoned your green card. You're okay. Okay, that's pretty much all I had to add to this. You folks have follow-up questions, go ahead and send us emails or join our community conference call. We'll take it up there. Thank you, everyone.